Thank you, Laura Washington. Joining us now is Laura Coates. You know her as a CNN senior legal analyst. She's been on prime time these last few weeks. She's also a Sirius XM host. She's joining us today because she's the author of a new memoir, Just Pursuit, a Black prosecutor's fight for fairness. It's a story about her time at the Department of Justice in the Voting Rights Division and as a federal prosecutor. And we're going to talk today, Laura, about your book and about President Biden's pending Supreme Court choice, where he has promised to make good on his pledge to nominate the first Black woman justice. Just a few facts first. In the history of our nation, since 1789, there have been 115 justices. All but 108 are white men. So those facts alone suggest that there has never been a search for the most qualified. That's always been a myth. Let me read a line from Laura's book, and then Laura will jump in with you. Race permeates our entire justice system and informs and even defines what justice is and who it's for. Now, Laura's book is a series of chapters on her stories in the justice system. And Laura, can you tell us, there's one, Chapter 5, That's Not Me, on the case of mistaken ID, when you say that Black defendants must defend themselves against the charge as much as the stereotype it negates a presumption of innocence. Can you tell us the story about a cop who couldn't tell two Black men apart? And then we'll work this into your book, which is out at this very timely point in history.
Well, I'm so glad I'm here, and thank you for this conversation. And the sad truth is that these topics are so evergreen and they're so pervasive for a reason, which is why I wrote this book. And it is episodic in nature to really personify these issues that have been a part of the national zeitgeist. And that chapter talks about the perspective of, you know what it's like when we hear about the national headlines of somebody who's been exonerated after spending decades in prison, and they're sent away with money in their pocket, perhaps, and a paper bag, and hopefully the expectation of the people that were with them on the outside will be there to meet them in the end. But how about those moments, the overwhelming number of moments when a blink, that blink moment, so to speak, that stops that in its tracks, when the wrong person is being accused of a crime and is asked to hold to account for that. Well, in this instance, this chapter speaks about that blink moment at the infancy of this sort of case, of a man who was claiming and professing his innocence, which, as you can imagine, in a criminal courtroom happens thousands of times an hour with a presumption of innocence. But here he was saying that it wasn't him, that the warrant squad had picked up the wrong person. He had not savagely assaulted a woman, nor fathered a child with her, but no one would listen to his pleas. Nobody assumed that he was innocent. And the judge invited me to join in on her mockery of this man and his profession of innocence. But it was the dynamic, as you speak about, and how race infuses so much of it. And I don't have the luxury of entering a room as anything other than I am, a Black woman with lived experience, a proponent of civil rights, a wife, mother, and daughter, a student of history. And in that moment, that dynamic, I could not, because I do not approach the law robotically, I could not approach it and join in on the mockery or the notion that police officers are infallible when we know that at times they get it wrong. And I wish I could tell you through that chapter that there was some cape on my back where I went the extra mile. The sad reality was you only needed to go the extra inch to have a healthy level of skepticism, knowing the role of race in our criminal legal system. It's aspiring to be a justice system, to show that this man deserved that presumption of innocence. And but for those blink moments, he never would have gotten it.
Yeah, one of the things that at the top of the justice system is the Supreme Court. And you talk about the role of privilege in charging decisions. Can you tell us a little bit about that? And then we'll talk more about the Supreme Court and mix in your book as we do it.
Of course. Well, first of all, we know how we talk about privilege and the idea of those who are entitled or feel entitled to be puppeteers, pulling the strings and the different levers of justice, et cetera. Well, this is certainly true in corporate America and the greater world, and the microcosm that is our legal system. And I, on the one hand, was a beneficiary of a kind of privilege by virtue of being an extension of law enforcement under the executive branch of government. How often have you heard someone say, well, where there's smoke, there's fire, or the officers wouldn't have arrested that person if they hadn't done something, or surely the federal government would not be charging this person but for them doing something wrong. And that can oftentimes chip away at the presumption of innocence, which we, of course, have to pay for in this country. And so knowing that I was a beneficiary and part of that kind of privilege, it was always important to understand how one wields that privilege. On the flip side of that, you had people who would normally come to the justice system and asking for their grievances to be redressed. But the sad reality, which often feels harsh for people, is there are limited resources available even within the very expansive government. And we make routinely decisions that oftentimes might feel like a slap in the face to victims of crimes as they're waiting to see whether we can devote the requisite level of resources to the more serious or more violent crimes, or draw our attention and hone in on other cases. And sometimes those cost benefit analysis leave people wondering who justice is for, but also make people feel like they're going to pull those strings of privilege. And if you're going to put anything on the chopping block or devote little resources or minimal in other ways, then it better be me. And issues of race and socioeconomic status, sometimes politics, come into play for people to feel emboldened enough to do that.
Why would it matter if a female Black woman was nominated to the Supreme Court, Laura?
It would matter because we're asking this Supreme Court. We look at the Supreme Court, this judicial nine, as the place where the buck stops. And we need to have diversity of perspective on that bench to ensure that it represents the people, the viewpoints, and the precedent in this country. So much of the law is nuanced. It's rarely ever black and white. And it's the in-between that allows you and requires you to bring your lived experience, your professional experience, your common sense, and of course, dignity into the courtroom as well and on that bench. So it's not a guarantee that someone's gender or race will be predictive of how they will rule, but the idea of having somebody there with the lived experience, the historical reference points, and differing perspectives is invaluable. And as you noted at the beginning here, I mean, nobody seemed to doubt the idea of the value of different perspectives when it came to the 100+ white men who sat on the bench. Nobody seemed to bat an eye in some respects when even President Reagan said he wanted to have a woman on the bench in the form of obviously Sandra Day O'Connor, or even George H.W. Bush wanting to have a successor of Thurgood Marshall as a Black man. Now we note those two could not be more diametrically opposed in their ideology and philosophy. But this idea of this being a novelty, of having a president be specific about the kinds of perspectives. I mean, the Trump administration essentially outsourced to the Federalist Society a list of judges hoping to have a particular result with respect to Roe v. Wade and other precedent. That also invites partiality. However, the selection of somebody based on their experience and what they might bring to the court and representation, that's not inviting partiality. That's inviting America into the Supreme Court.
Well, Laura, I would like to ask, following up on that, is there something about, you say that people didn't question Reagan, and this has not been the hot button topic that it seems to be today. It seems to be what you're saying. What's different about today? What's going on in these times that do you think is changed the attitude and is delivered this kind of a response, this very negative response to the idea of having a Black woman on the Supreme Court?
I think it is the frustration that the notion that somebody wanting to have a Black woman is somehow a liberal ploy or a way to make the court more partisan. And the idea that relegating Black women as if they are a political pawn and that they are involved in the game, as opposed to recognizing that, frankly, of the short list we have seen, we're talking about an embarrassment of riches of qualifications. And it's an embarrassment that we have yet to have a president very precise and adamant and resolved to have a Black woman on the bench. But I think what you're seeing in the land of misconstruing the application of the critical race theory, discussions about the role and impact of race in education, the idea of a bit of white frustration about feeling as though they're marginalized in a Browning America, so to speak. I think that the reaction, if there is any, is really reactionary to those frustrations and grievances and have nothing to do with the fact that we've got, at least from the list we've all seen, extraordinarily qualified women who would be an asset to any bench, let alone the Supreme Court.
Well, you know what? Go on, Laura, please.
So how do you see, you say that you think that there should be no question about the potential candidates that Biden may be looking at. So, but there are going to be questions. There are already been questions raised. How do you anticipate this rolling out? What's your analysis of how challenging this is going to be to get this nominee through, and where are the pitfalls?
Well, if we were in a world where there would be no questions or everything was a walk in the park when it came to Congress, none of us could now find that strange world on a map any longer, right? Washington, D.C. is not known for the efficiency of a beehive. Bureaucracy obviously will come into play. Politics will come into play. But the thought is not that none of the women should be questioned on their qualifications in the sense of any other candidate going through a confirmation hearing. The notion is that they should have the same fair opportunity as everybody else to participate in this process. And in the end, if they have the requisite number of votes, they ought to be seated like everyone else who's come before these confirmation hearings. To the extent that hypocrisy finds its way into discussions, I hope it's pointed out. The ideas of if questions are about the tenure that one has sat on a bench in an appellate bench, well, we can look to the most recent justice, Supreme Court Justice Amy Coney Barrett, and talk about, are the same comparisons being drawn? If it's discussions about the school, if it's discussions about what number of cases that have been tried, what side of the aisle you found yourself on, were you a solicitor general in the office of solicitor general? Well, look to a seated Justice, Elena Kagan. There's so many facets of this I'm talking about, and the idea, and all I think anyone should ever ask for. No one is entitled to the position. They are entitled to the opportunity to be treated fairly through the process, and that must happen.
Right. And, somehow the notion in this discussion that we had a fair process up until now is something I think we have to repeat and keep repeating. Sometimes we're overwhelmed with data and we can't see through the fog. There's only 115 data points here, and when 108 turn up the same result, we don't need a lot more to say that something happened. Okay. And it also happens in a lot of ways. Biden has been adamant about having defenders on the court. Now, the one diversity issue that we'll address, I suppose, at another time is a non-Ivy League justice. Amy Coney Barrett was from Notre Dame. One of the reasons Senator Lindsey Graham of South Carolina has a pick that he likes is not only is she from his state, but she went to a school in South Carolina. So there's a lot of ways, I guess, to go to say what a court should be to reflect the nation. And that all I know and we know is that at this point, it's only been about one way. So there are so many discussions you could have in this area, but this one seems to me a little bit simpler because those scales of justices have had 15 pounds on one side and 0 on the other. Laura Coates, what do you think?
It's very true. The idea, and first of all, that you were alluding to as well about the fairness of the process, we need not go much further than even the now Attorney General, Merrick Garland's confirmation process that never happened in terms of the way in which politics has infused the notions of who ought to be on the Supreme Court, who ought to have that position.
And by the way, Laura, Merrick Garland is from a Chicago suburb, so we have covered him a lot. He grew up a few miles from me. So we are well versed on how the Republicans just blocked him from even getting a hearing.
And as he well should be. Across the nation, we should know about this, mostly because, not only because the indignity that he experienced, but also the idea of how it really reinforced the notion that I think so many people have about the Supreme Court, which is that it's a political arm of Congress or a political extension of our government. And it's supposed to be apolitical. It's supposed to be with a robe, the figurative symbolic notion of cloaking oneself with that robe, to be able to come in as that co-equal part of a co-equal branch of government, to have those checks and balances. And frankly, we talk about the different ideological wings of the court. Those are things the media has said, the public opinion has said about it. The conservative justices, the liberal justices, they don't consider themselves in that realm. They don't identify in that way, even if it's accurate. And so the Supreme Court has done itself no favors, frankly, in on the one hand, professing to be apolitical, and then doing things that essentially not only feed into that same opinion, whether it's notions of waiting to hear cases about alleged racial gerrymandering gerrymandered districts until after the elections are over, or whether it's discussions about, hey, we've got this valuable precedent, and until we change the precedent, that's the law of the land, unless you're in Texas and find an end run around that actually offends our precedent that can be used other places. Or, here's the thing we're talking about. We want everyone to know that we look at these issues objectively for the first time, but then they are aware fully of how there has been a vested interest to secure justices with a direct motive to overturn certain precedent. There are so many aspects that I think need to be really resolved and to be explored further, and to have the Supreme Court really be one of its best allies and champions to confirm to the American people they are apolitical. But the idea of a diverse candidate who might face a confirmation hearing, that's not in and of itself someone saying that, hey, this is showing how political it is. That's about who sits on the court, and the people who sit on the court, frankly, in many respects, ought to reflect the overwhelming of cases that happen across our country, the representative population, and also the opportunity for that perspective. So I hope that the Supreme Court, frankly, understands and evaluates why that perception is the way it is and tries to change it.
Well, politically speaking, though, as a practical matter, what might take some of the fireworks out of this nomination, no matter who she is that she is going to replace Justice Stephen Breyer. Right. So the pick won't upset the, how do we want to say, the conservative liberal ring. Lately, people have been talking.
Unlike, say, late Justice Ruth Bader Ginsburg to an Amy Coney Barrett, which did shift it in some respects.
Absolutely. I'm just curious, when you became a federal prosecutor from the Office of Civil Rights, did you have any idea of how this chaos that you would come into the system and the role that race played?
I think intellectually, I understood, obviously, the impact of race on our justice system. But until you actually experience it in a criminal courtroom in particular, you don't really understand to your bones. I often equate it to the distinction of, knowing the power of a locomotive, knowing the speed at which it travels, knowing the ferocity it brings. And then there's one day you're actually on a platform and one whizzes by you and you feel the reverberations of it in real time and you realize the force you're dealing with. That was sort of the transition for me from going from the idea of ideologically and esoterically understanding the impact of race and bias in our system, and then seeing it when you walk into a courtroom. I mean, over the years I was there, I can count on one hand the number of white defendants I ever saw in a courtroom. How can that be? Black and brown people don't have a monopoly on crime. It wasn't as simple of an explanation of, oh, this must be white officers who are profiling. We had Black and brown officers as well. And of course, Black and brown victims. So this idea of how all of it comes together in this sociological intersectionality and the impact of priorities that are set by the prosecutors' offices and political appointees and the like, and the expectations of the way in which impartiality is so often undermined by existing stereotypes and these false notions, all of that works together. And so I have to admit, even as intellectually as I approached it, no one is quite prepared for the reality of the imbalance. I
know I covered courts, and when I saw how it really worked, this is years ago, I thought, oh, not what I thought. Right. So going back to Supreme Court, as I hope most of our viewers know, when there is a nominee, the hearing will be led by the chairman of the Senate Judiciary Committee, who is Senator Dick Durbin, who I think is preparing for this historic moment. If you were a senator, Laura Coates, what do you think is an important question to ask? And you probably listened to some of these hearings through the years, most recently, Amy Coney Barrett.
I would ask how they actually felt about precedent in the Supreme Court. And I wouldn't be satisfied by the script that so often said, you can probably, much like the Law and Order script, everyone remembers, and the Miranda warnings of what your rights remain silent. So often it's true now of the idea, well, I couldn't possibly comment on a case that might come before me and in the court. And they sort of take under the desk all the law review articles they've written in the past 3 weeks about the very issue, but they want to say that this script to follow it. I would actually hone in on this notion and acknowledge the fallacy that people are not going to have opinions on matters of extraordinary importance, particularly for a lifetime of position. And while it's true, they ought not to be showing their hand fully, it would be a fallacy to assume that they have no opinion whatsoever, even on the strength and the validity of precedent. And if they are willing to overturn precedent, I'd like them to lay out why, what are the instances, and why there would be a public perception and backlash on the type of thing we've relied on as a society. That to me is extraordinarily important and really transcends all of the questions, because the only reason the Supreme Court, frankly, has legitimacy in terms of the value of its precedent is because of, in many ways, political inertia, that things have always been that way. But haven't we seen over the last 5 or 6 years that a country can't be governed, democracy can't be sustained on the notion of maybe a gentleman's agreement or a lady's handshake? It really has to be something more foundational. And I want to hear from a Supreme Court justice about their precise views. Take the script away, your precise views on the value and impact of precedent and if it's overturned.
And you think they would have to answer that?
I think they should have to answer that. I mean, again, I think that we have in many ways over the past 3 or so Supreme Court nominees and more, by the way, we have allowed that sort of coasting, allowed the notion of, okay, well, that's what we expect to hear. And it becomes almost a ministerial sort of role in the confirmation hearings. Although we, of course, remember that there was at least one Supreme Court confirmation hearing in Brett Kavanaugh that was not in any way the status quo or one that we were accustomed to for the reasons that we all know. But I think we do need to press on these issues. I think we do need to press on a lifetime tenure appointment and what it would mean to acknowledge this is the highest court in the land, and the amount of discretion and prerogative that can be exercised, it needs to be tested. And frankly, I think that question should also be fielded by even existing Supreme Court justices so that we may know how they truly feel about the honor of their position.
Well, that would be hard, but
yes, it would. And they won't answer it. But you said, I'm senator right now. So we are going to have my particular wishing well that's full of my available wishes. There you go.
Anyway, we're out of time now. Laura Coates, thank you so much for joining us. Laura Coates, the author of Just Pursuit, A Black Prosecutor's Fight for Fairness.
Lovely talking to you. Thank you.